Hi, I'm Tom Giannotti, an attorney with the Butler law firm. Today I want to talk about the differences between state court and federal court. Now, for most non-lawyers, this probably seems like, who cares? But, and sometimes it really is not a big difference. But there are some significant differences in terms of just how parties who are litigating cases have to be aware of certain deadlines. And those I've outlined behind me. Again, as far as the actual substance, though, of the different courts, it really goes more into a issue of subject matter jurisdiction. And the idea here is that federal courts are courts of limited jurisdiction, meaning that they can only hear certain types of cases. Those cases are typically cases involving a substantial question of federal law, or cases where the parties are citizens of different states. And these were the latter category of cases, called diversity of citizenship cases. Historically, the rationale behind this was that to allow a party who's a resident of one state to litigate in his or her own state, home state that is, would subject the other side to an unreasonable risk of bias, local bias, right, in favor of that state's resident, as opposed to the out-of-state resident. So if you ask me, that's a little bit less of a concern now, I would think, given that people are much more mobile and connected than they were historically. I would hope that the sort of provincial biases that once permeated this country have lessened in the 21st century. But nonetheless, there are a lot of parties that really want to be in one court or the other, and there are valid reasons for that. I won't get into all of that. Those are questions of strategy that are decided on a case-by-case basis, and there are going to be, in different types of cases, different pros and cons to each venue, and then that's up to the lawyer to make the best determination for his or her client. What I want to do, though, is just to kind of give a brief overview, as I alluded to. I have behind me the differences in just how the parties are litigating cases. So when you file a lawsuit, the other side gets a certain amount of time to answer. Right? In state court, that's in Georgia, that is. In state court, this is 30 days. But in federal court, it's shorter. It's 21 days. We count by touchdowns. In state court in Georgia, same 30 days. If a party files a motion, well, any type of motion, the other side gets 30 days to answer. So lawyers tend to like that, to be honest with you. But when we know that we're in federal court, we know we've got a strict briefing timetable, because in federal court, you only get 14 days for most types of motions. If it's a motion for summary judgment, those are typically more involved and require a lot more intensive briefing and citations to different parts of the record. So the courts thankfully recognize and give lawyers a little bit of a break there, and recognize how hard that is for the parties to meet those deadlines in 14 days, and when you're dealing with a motion for summary judgment. So the time frame is extended to 21 days for those types of motions. In both courts, parties can request leave of court for extensions. Generally, federal courts are less willing to give those extensions, at least in my experience. When you're litigating in federal court, you've got to be aware of these things. There are some traps for the unwary, and for that reason, federal courts require lawyers, even if you're admitted in the state of Georgia, to request separately to be admitted in that federal court in that district. So, for example, I'm registered or licensed to practice throughout the state of Georgia, in any state, any county, but I had to be separately admitted to the Northern District, the Southern District, and the Middle Districts of Georgia. Not like they're going to give you a pop quiz necessarily, but you do need to be familiar with each district's local rules. There are peculiar rules specific to certain jurisdictions in terms of the next thing on my list here, which is limits on discovery. This is where different districts get more peculiar in terms of the timing of discovery and the number of requests that parties can send. So, for example, in the Northern District of Georgia, which is where Atlanta sits, there are one of the limitations on discovery is that there's a conference called the Rule 26F conference. I'll just call it a discovery conference. This is what it is. The parties basically have to confer about what their different positions are. They have to exchange initial disclosures. This is true of any federal court, but specific to the Northern District, that has to occur within 30 days of the answer, and then the initial disclosures would be exchanged within 14 days of that. So there's very specific rules to that jurisdiction. Now, another example, the Middle District of Georgia, for example, which is basically a strip from Columbus up to just above, like Athens, above Augusta, but that's part of the Southern District, believe it or not. That covers the southern part of the state. But that is a example of the Middle District. I mean, is an example of a federal district that has very low restrictions on the number of discovery requests that a party can send. There's I think it's 10 requests for admission, 15 or something like that, requests for production, and then I think 20 or 25 interrogatories. So, in Georgia, the numbers are much less restricted in Georgia state court. So that's another reason that sometimes lawyers prefer state court, just so they don't have to go seek special permission from the court to send additional discovery, explain why. If your case is complex, you need these additional discovery requests. You get the idea. So, another just quick example of how the discovery timing is different in the state and federal courts is that again, discovery in Georgia just starts after the defendant answers. You can start taking depositions and exchanging written discovery, and that lasts for generally 6 months unless extended by the court. And if parties need more time to complete discovery, depositions, things like that, the courts are generally more likely to give those extensions in state court, just as a sort of matter of experience. The federal court, on the other hand, you have to have that conference before the discovery can actually start, before you can start taking depositions. You have to exchange initial disclosures, and the idea is to streamline cases for resolution and not clog up the court's dockets. So valid reasons, just something to be aware of. And then finally, the jury pools, right? So in the district courts in Georgia, as I alluded to, they cover swaths of Georgia. So there's different divisions within the districts, and so whatever counties are in that division where the case is filed, then that's the counties that the jury pools are drawn from. So if you're in, for example, the Northern District of Georgia in Atlanta, you're going to get, it doesn't matter if the case arose in Fulton County, Cobb County, Gwinnett County, DeKalb County, et cetera. Those are, as long as they're in that division, that district as well, they're going to be drawn from all over. So if you have jury duty in the Northern District of Georgia, you may have jurors from all over Metro Atlanta. Whereas if you're called a jury duty in your home county of, say, Fulton or DeKalb, you're only going to be with other jurors from your county, as in state court. So hopefully this was interesting and informative. If you have questions for us or you're interested in learning more, please comment below, and we'd appreciate it if you could subscribe to our page and like this video if you enjoyed it. Thank you for watching.